So procedures relating to foreign company carrying on business in India. So foreign company definition is section 242 defines that a company which is incorporated outside India and having place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducting any business activity in India and in any other manner. So the Companies Act 2013 provides that detailed provisions for compliance by foreign company carrying on business in India. The following provisions will applicable for foreign companies. Section 379 provides that provisions of section 382, 386, 392, 393 shall apply to foreign company with or without exemptions. By the notifications, the central government may exempt some sections for foreign companies. So first 379 we will discuss. 379 is discussed about foreign company shall be deemed to be Indian company in following situations. When where not less than 50% of paid up share capital or equity, it has to be held by one or more persons of citizens of India or body corporate, or one or more companies or body corporate incorporated in India, or by one or more citizens of India or one or more companies or body corporates incorporated in India. And single or aggregate, a group of persons కావచ్చు లేదంటే single, they may be considered as that foreign company shall be deemed to be incorporated in India, shall be deemed to be Indian company. Chapter 22 of the Act of such other provisions they may be prescribed. Other provisions related to this. And after that, registration of registrar with company, registration with register of companies. The foreign company has to register with the register of companies whatever the required documents will be there. In case where such company was incorporated outside India, that related documents has to be submitted to in registrar of companies. Every foreign company shall within 30 days, the time limit is important here, within 30 days of establishments of its place of business in India, that has to deliver the following documents to the registrar: a certificate of copy that charter or statute or memorandum of association or articles of association of the company or other instrument in the sense whatever that certificate is there, that will be called as instrument, constituting or defining the constitution of company. And if the instrument is not in English language, that has to be translated. And after that, the full address of registered and principal place of business that has to submit. And after that, list of directors and secretary of the company that has to be submitted. And after that, name and address, the person who is responsible for taking the actions and operations in India, whatever the person we are appointing as an agent, that foreign company will appoint one person as an agent, because their operation has to be taken care of by the person has to within appointed in India. So that respected person's name and address, contact details, and everything has to be submitted with the registrar. So the fourth point is the name and address, or the names and addressee of one or more persons resident in India authorized to accept on behalf of the company service of processes and any notices and other documents required to be served on the company. So next, the full address of the office of the company deemed to be a principal place of business or a subsidiary place of business, that has to be submitted. And after that, the particulars of opening and closing of places of business in India and earlier occasion or occasions. And after that, whatever the declaration has to be submitted, whatever the person we are appointed as an agent in India, that person did not committed any mistake or convicted any mistakes in court of law, right? Seventh point వచ్చేసి declaration has to be submitted by the director of the company authorized representative in India has ever been convicted or debarred from formation of company and management in India and abroad. And after that, any prescribed provisions will be there that has to be applied as may be prescribed. And after that, any alteration has been made, any alteration has they were committed, they have to intimate to the registrar within 30 days after alteration. After that, they have to maintain a balance sheet and profit and loss account. 379 is discussed about foreign company shall be deemed to be Indian company. After the 380 will regarding registration with the registrar of companies, and after that 381 is regarding maintaining of balance sheet and profit and loss account. Every foreign company shall in every calendar year make out a balance sheet and profit and loss account in such a form containing such particulars, including having annexed and attached thereto such document as may be prescribed. And after that, deliver a copy of documents to the registrar unless exempted, provided that the central government may by notification direct that such companies may apply some provisions or not. So the first a provision is there. Every company shall have to maintain a balance sheet and profit and loss account. By the decision of the central government, they may exempt some companies, right? Shall apply subject to such exceptions and modifications as may be specified in the notification. And after that, if any such document as mentioned in subsection 1, it was not in English language, that they have to be submitted in, they have to translate to English language. Every foreign company shall send to registrar along with the documents required to be delivered to him under section 1, under subsection 1, a copy of the list prescribed form and place of businesses established, and after that the date of references, balance sheet and all they have to send. And after 382 is related to display of the name of foreign company. 383 is regarding serving of notices, serving of documents. Serving in the sense what? Sending of documents. Yeah, every foreign company shall conspicuously exhibit on the outside of every office or place where it carries on business in India the name of the company and the country in which they were incorporated in letters easily legible in English characters, and also in characters language of one or local language law. They have to show, they have to display the name. Any company ఏ కంట్రీలో రిజిస్టర్ అయి ఉంది, ఆఫ్టర్ దట్ the name of the company, right? Cause the name of company, the country in which the company is incorporated, the country in which the company is incorporated to be stated legible in English characteristics. ఈ bill heads, letter of heads పైన కూడా they have to show their company's name. And after that, they leave, if their liability is limited, that has to be showed in a letter of heads bill papers also. Next is serving of documents. 383, any process or notice or the document required to be served on a foreign company shall be deemed to be sufficiently served. So if addressed to any person whose name and address have been delivered to the registrar under section 380 related to registration with the registrar of companies, any other documents is required, they have been served sufficiently, they were deeming. Now that is sent by post or through electronic mode also. And after that, section 71, the provisions of section 71 will apply, shall apply for mutadis mutandis ante whatever the provisions are required, makes up such appropriate changes and apply. Changes are situation to తగ్గట్టు what are the changes is required, you have to change and apply, right? Mutadis mutandis means. After that, the provisions of section 92 shall subject to expectations and modifications, adoption as may be made therein, any rules made there under the act apply to the foreign company as applied to the company incorporated in India. Next, the provisions of section 128 regarding books of account, maintenance of books of accounts. So the foreign company shall require to be obey for the rules of section 28 also. And after that, section chapter 6 shall apply for mutandis mutandis regarding charges in the sense ఏదైనా అసెట్ పైన చార్జెస్ క్రియేట్ చేసి ఉంటే ఇన్ కేస్ ఆఫ్ టేకింగ్ డిపాజిట్స్ ఆర్ లోన్స్, they have to show. And after that, the provisions of chapter 14 shall apply mutadis mutandis Indian company, foreign company as apply for company incorporated in India. What are the provisions will Indian companies will apply, the same provisions will apply for the foreign companies too. And after that, we have a balance of sections regarding 379 over 380 381 382 383. Yeah, next we have regarding merge and wound up. These two provisions we will discuss, this session will be closed. Inspection, inquiry, investigation 228. As per chapter 14, whatever the provisions will apply for incorporation of Indian companies, the same provisions related to inspection, inquiry, investigation will apply mutadis mutandis, right? Next, merger into company registered under this act, vice versa. Section 234 subsection 2, subject to the provisions of the companies act, subject to the provisions of any other law for the time being in force. A foreign company may, with prior approval of Reserve Bank of India, they may get merged into company registered under this act, Companies Act, which was incorporated in India, or vice versa. Thus, whatever the Indian company will be there, that can be merged into foreign company. And the terms and conditions of the scheme of merger may provide, among other things, for payment of consideration to the shareholders, that may be by the form of cash or depository receipts. In case of foreign company లో consideration pay చేయాలంటే they literally accept the whatever the depository receipts will be there, we can accept, right? ఇక్కడ explanation ఇచ్చారు. For the purpose of this section, for the purpose of this section, foreign company definition వచ్చి company or body corporate incorporated outside India, okay, whether having a place of business in India or not. అంటే ఇండియాలో ప్లేస్ ఆఫ్ బిజినెస్ ఉన్నా లేకున్నా ఈ డెఫినేషన్ ప్రకారం we can take ఈ ఫారిన్ కంపెనీ ఇన్కార్పొరేటెడ్ అవుట్ సైడ్ ఇండియా, మర్జెస్ అనేవి చేయొచ్చు, మర్జెస్ దే కెన్ టేక్ ప్లేస్. అండ్ ఆఫ్టర్ దట్ 376 section 376 regarding winding up of unregistered company. Whatever the company which is unregistered, which is doing business activity in India, they can be get wound up. Where a body corporate incorporated outside India, which has been carrying on business in India, ceases to carry on business in India, it may be wound up as an unregistered company under this part. It may be wound up as unregistered company under this part, notwithstanding that the body corporate has been dissolved and otherwise ceased to exist as such under by virtue of the law of the country under which it was incorporated. Majorly important sections వచ్చేసి here 379 foreign company shall deemed to Indian company, and after the 380 registration with the register of company, and next balance sheet profit and loss account 381, 382 regarding display of name of foreign company, next is serving of notice, serving of documents 383, next after that wounding up and merger 234 376. With this we can complete 1.1.3 procedures relating to foreign companies carrying on business in India.